Welcome to Legal Aspects of Teacher Evaluation by Rachel Roberts for EDL 851, Module 8. What is an effective teacher? Any good teacher worth their stock wants to be effective, but how can you define an effective teacher? Darling and Hammond states that effective teaching is instruction that enables all students to meet or exceed ambitious goals for student learning. An effective teacher produces a year or more's worth of educational growth, compared to an ineffective teacher who produces less than a half a year's progress. AKA, students fall behind with your ineffective teachers. They don't meet their grade level expectations and they start regressing. So naturally, states and districts want an effective teacher in the classroom. But the issue becomes, how do you know if somebody's effective or not? Prior to the 2000s, evaluations weren't really discussed. However, teacher effectiveness came into question because of a lot of different factors. For example, there was a renewed focus on effectiveness of teachers because of the research on teacher quality. They said that boosting teacher effectiveness was the key to getting students to achieve better in school, and they started revamping state evaluation laws. Politicians even got involved and put pressure on the states to get rid of those tenured teachers who were not getting good performances from their students in the classroom. In 2009, the U.S. government passed the $4.3 billion bill called Race to the Top. This bill gave money to the state governments who revamped their evaluation process. The states obviously reacted because they wanted to receive the extra federal funding. Some reacted positively, some negatively, some a handful of both. For example, in Florida and in Washington, D.C., many schools and districts adopted the motto that they would give more money for teachers who had a higher evaluative performance. Of course, you would receive less if you had a poor performance. In Colorado, they dropped tenured teachers to probationary status after several poor evaluations in order to keep them motivated to try new things in the classroom. NEA and the AFT filed lawsuits as a backlash to some of these legal consequences passed by Race to the Top. NEA and AFT state that effectiveness should not be test-based. When you base an evaluation on a state assessment or a set of standardized tests, it doesn't consider the circumstances that are taking place in that classroom. For example, if you teach in a school with a very high poverty, chances are there's going to be some extenuating circumstances that are going to cause your students to struggle a little bit more than somebody who taught in an affluent district. It would not be fair to punish those teachers working in low-income school districts for poor test grades when somebody does not have as much content and technology may be available to them because of their income level. It doesn't also take into effect student effort, whether students try on a state assessment or not, or whether the students have special needs or special accommodations which might make testing difficult. So NEA and AFT stated that effectiveness should not be measured based on tests. There was also the issue of evaluating non-tested teachers. For example, in my school this year, the 7th grade social studies teachers did not give the state assessments, and obviously our extracurricular teachers don't give state assessments. According to the laws by Race to the Top, how would we measure those teachers who did not have any type of state assessment given? It would be very hard to measure their performance based upon how students performed in my class, which is an English class, which is assessed yearly. How could I measure social studies effectiveness based on an English test score? It's not fair. So there was a lot of discrepancies that the unions were all over trying to, find some common ground, some fair ground for evaluations. Not just unions sued, individuals sued as well. For example, the case Letterman versus King took place in New York in 2014. The teacher was a fourth grade teacher, and in 2012, she was marked as an effective teacher. She got a score of 14 out of 20. Yet the next school year, she was marked as ineffective, receiving a score out of 1 out of 20. For both years, she had very similar test scores. Her students were consistently scoring in the 65 to 68% above average for the English reading assessments and between 60 and 70% effective or on average for the math assessments. So both years, her results were the same, yet her evaluation was totally different from one year to the other, and she found that to be very unfair. She took that to the court, and her district could not really explain to her why she had been marked ineffective one year compared to effective the next. And they found that this was pretty arbitrary, that the judgment was not fairly given to her. She had a lot of data that helped back up her case, and they ruled in favor of her. They vacated her evaluation from 2013-14, and she got to keep her job. I teach in Seaman Public Schools, USD 345, and we have a pretty complex evaluation process. I recently just got off my probationary period. We have a 4-year probationary period, whether you've been teaching for, just your first job out of college, or if you've been teaching 20 years, you still come into the district in a probationary period for 4 years. You get 2 formal evaluations during years 1 and 2, and you get 1 formal evaluation in years 3 and 4. You get walkthroughs, multiple walkthroughs each quarter in the first couple years, and then you're required to have 2 walkthroughs each year for years 3 and 4 as well. Once you receive non-probationary status, you only get evaluated every 3 years. Our evaluation process is based on Charlotte Danielson's framework for teaching. We use a rubric when we have a very set procedure for evaluations. It starts off by having goal-setting meetings with our administrators at the very beginning of the year, talking about what we want to achieve. Then, once we've agreed upon a time for an observation, we have a pre-conference meeting in which we talk about what we're going to see, areas the teacher would like assistance on or feedback on. The administrator comes in and observes our lesson. Within 2 days, the educator has to reflect on what the lesson, how it went, and they also have to complete a self-evaluation form in which they fill out a very lengthy rubric about how they act professionally, how they conduct themselves as a leader, all these different types of criteria. And they have 2 days to get that in after the evaluation or after the observation is complete. And then, within 10 days, your administrator is supposed to meet with you for a post-evaluation or post-observation conference. At that time, you go over what they saw, you go over your evaluations, and usually they'll tell you if you're recommended for renewal or not. I've had several instances of colleagues who did get non-renewed, and there's been some issues in the elementary setting with administrators not meeting with their teachers in a timely manner. If you get non-renewed and you are a probationary teacher, you have no due process. You don't get notified as to why you are being let go. You just are non-renewed. You can always go to our Seaman Education Association, which is our union, to ask, for some rights. Usually they'll talk to the principal, but there's really nothing that you can do according to our contract. If you're a non-probationary teacher, you get due process. If you react within 10 days, you can take your case to the board office, and they will have a hearing as to why you were let go. You may argue your case, but it's got to be done very by the books. Otherwise, they're not going to even consider your rule. future implications for me as an educator. As an administrator, I'll make sure to follow our district framework for evaluation processes. Like I said, we had some administrators who wouldn't evaluate in a timely manner. They would observe you, and then maybe not evaluate or meet with you until several months later. For example, I got observed in early October, and my principal didn't meet with me until February to talk about my observation. That's illegal according to our contract and our negotiated agreement in my district. And so a lot of the elementary schools have that problem. We don't have that problem at my school now. My middle school is pretty timely about getting those things done. But as an administrator, I'd make sure to follow my framework and make sure I'm on time and in order according to how they want that done. I would also stay informed, make sure I keep track of what's going on in the state legislature and as well as what's happening in the federal government and regarding evaluations and how that's going to change. When I go to evaluate a teacher, I would remain open-minded. Just because they don't teach like I do doesn't mean they're not teaching effectively. There's lots of different teaching styles that can be used in a classroom to reach students of all learning abilities. And so being open-minded with my evaluation would be helpful as I moved forward. And last but not least, if I'm stuck or if I feel like I have to have an uncomfortable conversation with a teacher about their performance, I'm going to ask somebody for guidance. There's lots of principals in my district and lots of people with more experience than I would have, so I think I could use my resources to find somebody who knows what they're talking about so I can stay informed, keep myself out of trouble legally, and give a fair evaluation to my teachers.